Good morning. This is the time set for oral argument in Ferneau versus Wilder, our case number CACB 220328. Each side is allocated 20 minutes for argument. Appellant can reserve a portion of that time for rebuttal if you wish to do so. If you wish to do so, however, you need to keep track of your time at the podium clock. The court will not do that for you. And as far as appellees, I'm going to look to you as to how you're going to divide time, recognizing you get at most 20 minutes collectively. We've read the briefs. We've conferenced the case this morning. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. And out of respect for counsel and to avoid any unnecessary embarrassment, I would encourage everyone here to make sure your phones are turned off so our proceedings are not interrupted. Our proceedings are being recorded and will be posted to YouTube. As you begin your argument, please state your name and the party you represent. And I'm not so good with names, and with a name like Thumma, you think I'd be better. But Mr. Zarafi, is that close?
It's pretty close, Judge.
Help me.
Zarifi.
Well, yeah, that's not that close. So, but you're indulgent, and I appreciate that.
I get Safari.
Well, the Z caught me, but you may proceed when you're ready. And if you wish to speak from the podium or from your chair, as long as it's captured, that's the important thing.
Well, that's great. If you don't mind, Judge, I wouldn't mind doing it from my chair.
Are we capturing the microphone, just to make sure? Yep.
So I'm also in advance going to state that I'm going to try to reserve 5 minutes for rebuttal.
Very well.
If I can. So, Your Honors, I know you've reviewed the briefings and so forth, and it's a pretty discrete issue in front of the court. So what we had happen with the lower court is it removed my client, who was one of 2 directors in the company, under the nonprofit corporation removal statute. The primary issue we're presenting on appeal is a legal issue, and it should receive bid over review. And I think from our briefings, it's pretty clear what that issue is. It's that Judge Martin improperly grafted a constructive fraud standard into what is unequivocally and clearly in the statute a fraud or criminal standard.
Well, Counsel, can you explain why constructive fraud doesn't fit in with the statute?
Well, Your Honor, the legislative history with respect to that act.
Before we get to the legislative history, does the wording help?
The wording?
Yes, of the statute.
I think the wording of the statute helps our claim that it's constructive fraud alone is not enough to warrant removal under that statute.
And why is that?
Because constructive fraud, if you're looking at it on the spectrum between, say, negligence, and then you get to fraud with your intentional torts, constructive fraud is, although it contains the word fraud, it's a far cry from the actual fraud with respect to all of its 9 elements and the requirement that it be proved by clear and convincing evidence. Constructive fraud essentially requires that you prove that there was a duty and a breach of a duty. So intent is a big missing factor under the constructive fraud standard. And there's also an issue of a harm under the constructive fraud standard.
My question would be, under the language of the statute, before we look at the history, which I question that, but just first looking at the language, why wouldn't constructive fraud fit within the language of the statute?
Well, Your Honor, the statute, ARS 3810, it's pretty a small, short statute, and it's got an A and a B, and the A is, it says fraud or criminal conduct.
Actually, it says fraudulent conduct, right? Just to be,
Fraudulent conduct, I apologize.
no, I just want to make sure we're on the same page.
It's fraudulent or criminal conduct, and you've also got to show a second showing that the removal is in the best interest of the corporation.
Then, if the statute says fraudulent conduct, why wouldn't constructive fraud, which I think, yeah, unless you can explain why constructive fraud is not fraudulent conduct, then why doesn't that fit within the language of the statute?
Because constructive fraud, Your Honor, is, again, I mean, although there's no overlap with the use of the terminology, there's no intent required. It's a much lower standard than fraud. And Judge Martin previously...
But I'm going to follow up on Judge Howe's question. What in the statute, the language of the statute, specifically supports your position that fraudulent conduct doesn't include constructive fraud?
I would argue that the same sentence in the statute that says fraudulent conduct, I believe it says fraudulent conduct or criminal conduct.
Actually, it says fraudulent conduct or intentional criminal conduct. So your whole point about intent, doesn't the statute sort of negate your argument? Because if the legislature meant intentional fraud, it would have included it like it did in intentional criminal conduct.
Well, Your Honor, I actually reading it a different way.
Then I'd love to hear how you're reading it.
Insofar as I think that in that same sentence where it says fraud or intentional criminal conduct, I think when it's A or B, when I'm reading that standard, I wouldn't think if the B is intentional criminal conduct. A, if it's a choice between fraud and constructive fraud, I think it's a high bar. That's the way I read the statute. The element is the same element in saying fraud or intentional criminal conduct. Well, intentional criminal conduct certainly would be higher than even the common law fraud with its 9 elements. But to me, when you've got intentional criminal conduct in that same point of the statute, I don't think it would be, I wouldn't interpret the word fraud to include anything but something close to the intent, something with intent, because the second part of that is you have to have A or B, and B says intentional criminal conduct. And I'm trying to say, well, fraud, other than the fact that constructive fraud uses the phrase fraud, it's not, I mean, it's closer to negligence than it is to the common law because it's missing the intent factor. And B says intent, so I would think that A would also require a high showing.
Well, Counsel, the statute could have been written fraudulent or criminal conduct. They didn't. So the drafters wanted the criminal conduct to be intentional. I see nothing in the way that was worded that intentional is a backwards transitive to fraudulent conduct. That's my problem with your analysis. Are you saying that fraudulent conduct is ambiguous and we have to go beyond the wording of the statute?
What I believe is, I don't believe we need to go beyond the wording of the statute. I think that element in the statute, the first showing of the fraud or intentional criminal conduct, I think there's the difference between fraud and constructive fraud. The big whole difference is in intent. I think there's a requirement of an intent there. And the lower court had acknowledged that. It addressed the same issue of removal multiple times during the case and noted that it is, it is talking about egregious conduct and it's reserved for, the most recent conduct. So that's how I'm reading the statute. It says fraud or intentional criminal conduct. For me, the or intentional criminal conduct supports the idea that we're talking high-level fraud or intentional criminal conduct, some egregious conduct, not something that you accidentally would do.
But the plain language of the statute doesn't support that, so the argument has to be that phrase is ambiguous, so we have to interpret what fraudulent conduct means, correct?
I would say so, Your Honor. And I think that we're aided by the second. Yes, I would say that we do it. There's some room for interpretation.
Thank you.
Okay. And so essentially, the legislative history to the Non-Profit Act.
Counsel, let me ask you about that, because you described that in your briefs as legislative history. Isn't that like a committee of a section of the state bar that kind of described what they viewed as the statute doing, as opposed to anything from the legislature?
Well, Your Honor, I believe it was from the legislative history. I'm trying to pull it up.
It was Appendix D to the secondary source, if I recall right. And I thought that was a drafting committee comment of a section of the state bar. And that's why I wanted to make sure I was understanding the source.
I'm reviewing it myself.
Sure. Can I suggest that in the interest of time, if you want to look at that and address it perhaps in rebuttal? But that was a question that I had.
Yeah, I do note that we cited our citation cites the legislative history, but it's coming from a practice, the corporate practice series. And I know that, yes, you're right. Some attorney or someone does take that, so it's not the direct. I agree with the court.
So there really isn't legislative history about what the phrase means. There's only an attorney committee's view of what that means.
Well, there isn't. This citation that I cited is a committee's view, as the court had said. I do believe that the other instances of, well, actually, let me take a moment there, Judge. Oh, no, I would agree with the court. That is a committee's take on the legislative history preceding that.
So we're back to looking at the language and determining whether it's ambiguous or not. So your main argument is that the word intentional in criminal conduct is backwards translative to fraudulent conduct, and that's the only basis for your argument?
I know that that is how I'm interpreting it, Your Honor, and I know there's a lot of different rules of interpretation out there, and some conflicting, but I do believe that that first prong of that, so the second prong of that statute is it's got to be in the best interest of the corporation. I believe read in the whole, A and B, are talking about egregious type of conduct, high-level type of conduct. Something with if I'm, looking at torts on a spectrum, negligence to fraud, I would think, I'm reading that statute to mean something high level, not negligent.
And destroying 7 years of emails is not egregious conduct?
I think it could be. I think if, for example, if Judge Martin, when he made that ruling, one of his bases for the ruling was This issue of the email came about as, with the arising of another lawsuit against the company, aggregate task. One of Judge Martin's bases for ordering my client's removal was that he was committing spoliation of the evidence with respect to that case, which unfortunately we couldn't, because of the timing of the briefs and so forth, we couldn't include it in the index of the record. But in that case, I mean, the court takes judicial notice that that's been ruled on, and that they've found that there was no spoliation of the evidence. All those emails have been produced and turned over, and that's in a court order, and it's in a brief from the opposing counsel. So the harm, with respect to any harm, whether if we're looking at it under even a constructive fraud standard, Judge Martin, when he issued his removals, and it's in his order, ordering the removal, he said there's spoliation of evidence, which I would also take as something bad. But in fact, there was, now Judge Martin would have no way of knowing that back then because these facts developed later, but there was no evidence that was spoiled.
And counsel, where would we find that in our record?
So unfortunately, Judge, it's not in our, because of the timing of the briefs and the timing of that other case, it's not in our record. It is in the record of the other, this lawsuit, Aggregate v. Fast. It's in a court order, it's in a brief from opposing counsel, but it's not in our index.
And we need to be mindful that the record we consider is what we have.
I understand that, Your Honor. I just wanted to make that, noted for the court, because Judge Martin had based his decision in part on the spoliation of the evidence issue, and there's no way he would have known at that time because the other case hadn't developed, and we didn't get a chance to, just the timing of the briefs and so forth, the way it played out, we couldn't have. But if there was a way to supplement or the court to take judicial notice, that has clearly been addressed in that case. Okay.
And you go 439.
I went a lot faster than I thought. Okay, well, I will try to save 4 minutes here.
Very well. Time goes fast. It does. Let me look to counsel for appellees.
Thank you, Your Honor. Art Bork for the Appellee Total Accountability Systems 1, Inc., and I'll be making the argument for all the appellees.
Very well.
So try to condense things here. When the facts change, I change in terms of where I was going to start, as always. So I appreciate you bringing up constructive fraud. I've spent a lot of time on it, and I want to quickly, I didn't intend to do this either. I was in moot court at University of Arizona years ago, and I didn't read a case, and Edward Roll corrected me and said, Mr. Bork, took me aside and said, always read all the cases and the cases that cite the cases. And just want to give honor to him. The court was correct. It's not the legislative history of ARS 103810 that was cited by the appellant. The law in Arizona is that fraud consists of actual fraud and constructive fraud. And not only that, I want to drill down a little bit further. The case everybody knows, Green v. Lisa Frank, was viewing a statute which is virtually identical to this. It happens to be a for-profit statute rather than a not-for-profit statute. The relevant language is identical, and the court looked at the language and then evaluated fraud in terms of actual fraud, and then it looked at it in terms of constructive fraud. So we have the Court of Appeals that's weighed in on this issue.
But what is the difference between actual fraud and constructive fraud?
Yeah. Actual fraud, as we all know, is the Eccles 9 elements of fraud. And constructive fraud, I think the Dawson case lays out the test best, but it lays out two things, Your Honor. It lays out the test where you have to have a fiduciary duty or a confidential relationship, a breach of that duty, and then somebody relies on it to their detriment, right? That's the test. But I drilled down, thank you, Judge Roll, to align, Your Honor, so let's get beyond the wooden legal test. I don't want to call it wooden legal test. And here's what the Dawson court said. It says constructive fraud is a breach of a legal or equitable duty which, without regard to the moral guilt or intent of the person charged, and here's the key language, the law declares fraudulent because the breach tends to deceive others or violates private confidences. And the Dawson court cited two cases, Lasley, and it cited to a Morrison case. The Lasley case was a case where a doctor prescribed sleeping pills to a patient. The patient had a bunch of problems over the years, came to the doctor and said, hey, things are going wrong with me. And the doctor said, don't worry about it. It'll be fine. And then ultimately the patient, the patient's daughter intervened, and the court said, hey, citing Morrison, which was a case where a dentist did surgery on somebody and left material in the person's mouth, and the person for 12 years didn't know they had materials in their mouth. The court said, when you have a fiduciary duty, or physician-patient privilege, these are more than just regular duties. They're obviously much more than arm's length. I think one of the courts said it's a sacred duty, right? And that's what you have in a situation. That's where constructive fraud comes from. I went all the way back, and I won't bore you with the details of constructive fraud, but it arises from that duty. And the law, and this is from the Dawson case, literally declares it fraud because of that effect. And the Green v. Lisa Frank case recognized that when they viewed the exact same statutory language that's in front of your honors and said, and did that analysis. So I think it's settled Arizona law that under the statute, fraudulent conduct includes all species of fraud. In fact, I cited to the McDonald's estate case, which is Arizona Supreme Court, which they say fraud has two species, right? Actual fraud and constructive fraud. So you have, clearly under the statute, I would say, obviously it's a constructive fraud. But
so how was constructive fraud committed here?
this is similar to the 12-year dental case. Here's what happens here, and it's really undisputed in the record, Your Honor. There's three main misrepresentations relating to both actual fraud, which I think actual fraud exists in this case, all 9 elements, and constructive fraud, and separate from that, intentional criminal conduct, and we've cited the court to those 6 laws. Just as a quick digression before I answer, Your Honor, under Arizona law, the court can look and decide whether there was a preponderance of the evidence that would support all 6 of those crimes, rather than a beyond doubt standard. Because like a RICO claim, the underlying predicate acts in a civil case don't need to be proven beyond a doubt. Although I will say that if you look at Dan Martin's ruling, Judge Martin's ruling, he says beyond doubt, and I'm paraphrasing, Mr. Ferneau was lying. But the constructive fraud in this case, Your Honor, is, let me talk about 3 distinct representations and omissions. Mr. Ferneau says repeatedly, both personally and through his attorneys, I am safeguarding the corporate emails. I am safeguarding those emails. That's one representation. Second representation, I don't have the password. I don't know what the password is to this account. Third representation, I can't get into the account. Every time I try to get in there, it's a black hole. Okay? So you have these 3 separate and distinct representations, all of which are actionable fraud and constitute constructive fraud because Mr. Ferneau had a fiduciary duty to TASS as TASS's director. Now,
Then with those representations, false they may be, how was your client harmed by that?
TASS was harmed by it because it delayed in bringing legal action. It waited and waited and waited, believing Mr. Ferneau, who had various stories, until December of 2020, when it believed it needed the missing documents. There were multiple folders, Your Honor, that had missing documents. And we've all, everybody here can, the common experience is you go into your email, you delete something, and then there's a trash box, right? The trash box here was empty as well, okay, when people got into it. So Tass and Ms. Wilder rely by waiting and waiting and waiting. And Jeff Sertikowski, the attorney for Ms. Wilder, even has these long machinations with Mr. Ferneau and Mr. Ferneau's other lawyer, Mr. Brower, where they're going through this process that you saw to try to get the Gmail account open, right? And after we waited, right, waiting, we finally get into the account. And there's only one reason we got into the account. It's that because Judge Martin on January 20th hailed Mr. Ferneau and his counsel into court and said, you're going to have to give access to that account. And when we went to get access, there was nothing in the account. So you have reliance, and then you have the injury of having essentially, there were some table scraps in the account, but you had 4 years of government-required documents in that account. Your Honors,
Well, counsel, I take your argument. I was surprised with the argument by your colleague, though, that there was an explanation of the evidence. And I know that's not in our record, but where does that come from?
Yeah, it's number one, you're right, it's not in your record, and counsel's wrong. I'm the attorney in the other case. I'm handling the case in front of Judge Moskowitz. Judge Moskowitz was very clear, and I made the argument. What Mr. Ferneau did damaged Tass, and it was spoliation against Tass. Mr. Ferneau was not out to harm Agricam. He was out to hurt Tass, and he did so. And Judge Moskowitz agreed in denying the motion for default judgment against Tass in the Agricam litigation, and he clearly said in his ruling, and I can provide that to the court if the court would like, Judge Martin specifically found spoliation with respect to Tass's documents, right? Not with respect to Ferneau trying to injure Agricam.
Okay.
And the other thing is, Your Honor, setting aside the Agricam matter, you had, again, 4 years of state-required documents. And we've cited to the statute, those records are required to be kept for 5 years. By deleting the documents, Ferneau put Tass in immediate violation of Arizona law and subjected Tass's medical marijuana dispensary license to revocation by the state.
So the court's ruling in a case that's not before us that we shouldn't consider doesn't have anything to do with spoliation as it pertains to Tass.
Yes, Your Honor, it has nothing to do with this case. It's been inaccurately cited, and I'll give counsel the benefit of the doubt because he's not the one, in the pits, so to speak, on the case.
Sure.
And by the way, I almost forgot to say, if you read Judge Moskowitz's ruling denying the motion for default judgment, he said that the opposition could re-raise the issue at trial. So we're still potentially facing that issue. It's not over. It's not over at all. You didn't hear counsel, and granted the questions didn't go to the facts, Your Honor, but Judge Martin, he was uniquely positioned in this case. Rarely do you have a jurist like Judge Martin who's dealing with a guy personally. He knows him for 4.5 years, right? And when he made his decision, it was on 4.5 years of a record, and the court has that in front of the court. You'll notice in the opposing brief, there's a big void there. It's like a Sherlock Holmes, the dog that didn't bark in the night, the silver blaze, right? Why don't they discuss it, right? It's completely relevant to the issues before the court. Judge Martin was so careful in this case, Your Honors, and I want to set this up because these cases come to you and you look at it and you do a great job of looking at it, but you're only looking at the briefs of the counsel. But let me tell you how that September 28, 2021 hearing, that's myopically all they want to look at. Please don't look at anything else in the previous 4.5 years. See no evil. Here's how that came about. Mr. Ferneau admitted no less than 8 times, I have it on the record, that he had access to the Gmail account that we're talking about today. No less than 8 times. He admitted through my name gets butchered too, it's Bork. My brother's name was Robert Bork, and he gets chided about that quite a bit. So, opposing counsel, number one, opposing counsel admitted in front of Judge Martin on January 19, 2021, that Mr. Ferneau had access to the Gmail account. He then admitted in open court on January 20th, 2021, that Mr. Ferneau had access to the Gmail account. That's 2. Once we got into the account, Mr. Sifferman wrote a letter to Mr. Ferneau's other counselor, an email, and said, hey, look at all these missing emails. What happened? Here's number 3. Mr. Brower, Mr. Ferneau's attorney, wrote back to Mr. Sifferman and said, Johnny Ferneau or his son deleted the emails in the Gmail account. So that's the 3rd admission. 4th admission, February 17, 2021. After having 3 weeks to consider TASS's application to remove Mr. Ferneau and dismiss the claim, so they had tons of time to think about it, Mr. Ferneau's counsel files a response to the application and says, Mr. Ferneau deleted the emails. In fact, they were almost proud of the deletion. You'll see it in the record. They say, the email, this is in the February 17, 2021 response. The emails in the BC Wellness Center account were deleted before the court's order, not after. So they want credit for deleting the emails because it was before the court's order. So they say. And then they say in another portion in that response, so emails were deleted from the BC Wellness Center's email account well before the court ordered Ferneau to provide the password response. So that's the 4th admission that Mr. Ferneau had access and deleted the emails. Even though in their opening brief in this case and in their reply, they said Judge Martin didn't have any evidence in front of him to make that conclusion. Okay?
Counsel, let me ask you, and I think you're getting to it. You're talking about admissions or statements by an agent of a party. Given the consequences here, dismissing a claim, which is a pretty substantial sanction, help me understand what came from plaintiff's mouth directly that the court relied on.
Yes, from the plaintiff's mouth directly, let me give you an example, Your Honor. At page 54 of the transcript of September 28, 2021, Mr. Ferneau, in response to questioning, I think by his own attorney, said that he contacted, after the court's order, he contacted a computer guy, KJ Kukta, and Kukta said, hey, do you have any passwords for the account? That's how we can get in. And he said, and Kukta told him, it's on page 54, and it struck me. I saw it for the first time yesterday morning and connected it. Ferneau said, yeah, I've got like 3 emails. He goes, here, give them to me. And Ferneau gives him the email, and Kukta gets right in. So I was at the gym this morning, and I heard a guy say on the phone, do you remember Mom's password? It was crazy. We all know that it's not brain surgery, even if you don't have a password to get into a Gmail account. And now we know that Ferneau admitted he had the password. Now, he might have had 2 other passwords, but he admits it from his mouth. He was also cross-examined at the trial, and I believe it was Mr. Sifferman or Mr. Swenson cross-examined him on his sworn deposition testimony that he had access to the Gmail account, and he was given access by none other than Mitch Cole. Mitchell Austin Cole, the agent provocateur that Judge Martin repeatedly reminded him should not have access to anything related with TASS. And that started, Your Honors, in 2017. In December 2017, Judge Martin first ordered Cole should have nothing to do with this case, and then in April of 2019, after an evidentiary hearing, he made findings that Cole had tried to cause another task director, Paul Berkey, to destroy evidence. So Mitchell Austin Cole and Johnny Ferneau are a package. Judge Martin knew it. You might recall in the record, Your Honor, Mitchell Austin Cole in July of 2021, you'll see in the record when Ferneau and his lawyers submitted a false public document. They whited out Mitchell Austin Cole's name to try to deceive Judge Martin and not let him know what was going on. So,
And I understand that. The reason for my question was with a sanction like this, sometimes misconduct is attributed to a lawyer, sometimes to a client, and for a sanction like this, I think the law indicates it has to be attributed to the client.
yes, and by the way, Your Honor, in Judge Martin's underlying rulings, he specifically made rulings, at least on one occasion that it was Mr. Ferneau's individual conduct. And none of those underlying rulings by Judge Martin have been appealed in this case.
Well, what was the specific basis for the case-ending sanctions?
The specific basis is set forth in Judge Martin's ruling, and he went through the litany of misconduct over 4.5 years, and Your Honor, and he specifically applied each of the factors of the Green v. Lisa Frank test. And I see I'm running out of time. I apologize. And I would ask the court to look at that test. This is not a case where Judge Martin just woke up one day on the wrong side of the bed. It's probably 25% of the guy's legal career he had to deal with this, and he was very careful in his rulings. I mean, as early as April of 2018, he warned Mr. Ferneau not to keep engaging in this sort of misconduct. And then after that, Mr. Ferneau and Judge Martin again made a ruling, conspired with another party, Yavapai Cash and Carry, and they deceived Judge Skelly, who was the receiver for the company. I mean, I can't go on and on because I've got 10 seconds. With great power comes great responsibility, Your Honor. He was given power as a corporate director to follow, and the responsibilities of fiduciary duty. He was given power as a litigant, and under Rule 11, you've got to follow those rules as well. And he breached that power. We would ask the court to affirm Judge Martin, who is a gatekeeper in this case. Thank you.
Thank you.
Your Honor, I have 15 seconds to address something that Judge Ferneau.
Let me look to my panel mates. We made it pretty plain about 20 minutes, but I'll give you 15 seconds and you'll get 15 more for rebuttal.
Your Honor, you asked the question, Mark Zifferman,
Yep.
my clients are Christine Wilder and Christine Wilder Life Holdings. Exhibit 68 at the evidentiary hearing, admitted in evidence, was the portion of Mr. Ferneau's deposition from back in February 2013, where he confirmed that his discovery responses said that he had access to the Gmail account, and he explained in his deposition why he did that and how he got access, and he got access through Mitch Cole.
Thank you. Rebuttal.
Thanks. Thank you, Your Honor. So I'd like to quickly follow up on Judge Howe's question of what's constructive fraud and fraud. Constructive fraud is simply a breach of a duty without any showing of intent. And it's very unfortunate that, so if we're going to use constructive fraud, an equitable remedy, and graft it into the statute, and we're going to say no intent, and then we turn to the question of harm, and we have it in another case. This issue of the email came about because of the initiation of this other lawsuit, and in that lawsuit, and it's just unfortunate that we don't have that, because from the full day evidentiary hearing, you heard counsel talk about previous representations by counsels for Mr. Ferneau about the email. So we had a full day evidentiary hearing on September in September that preceded the court's amended entry, had an entire day. There is not anything that was said or contained in that hearing that establishes any harm. So now you've got, so we're talking no intent and no harm.
So no harm came from the destruction of 4 years of emails.
Well, with respect to that comment, Judge, about the harm, Mr. Bork was talking about, well, no, that it's in Judge Martin's ruling that the spoliation of evidence was in relation to TAS and not Agricam. The ruling, it's on page 3 at the very bottom of the ruling. Judge Martin said, Ferneau intentionally destroyed valuable and irreplaceable TAS property and committed spoliation of the evidence. The very next sentence, he purged the email account knowing that its contents are critical to TAS's defense of the Agricam lawsuit. I mean, if that factored into his decision, at that time, Judge Martin had no way of having a crystal ball and knowing that that's not true. There was no, the spoliation of evidence does relate to this Agricam lawsuit, and it didn't happen. And so what you've got, what you've got here is, and the consequence here is severe. It's not, it may not come through in the briefs. Mr. Ferneau, it's removal, and by the way, the statute talks about a temporary removal, up to 5 years. And there's no mention of that. There was no, the time basis for his removal or any of that wasn't not discussed. It wasn't a part of Judge Martin's ruling or what have you. Mr. Ferneau getting removed, this is a man who's in his late 70s. He started in this company, and it not just removed him from the board of directors, it also took a big amount of cash flow that was coming in every month and just stopped it and took it out of his pocket. So with such a severe consequence, you would expect that there would be a high bar that should be shown to match that severe consequence. One day he's going from having all this money coming in every month, next day having to drive an Uber just to make ends meet for his family. This is, for that kind of a consequence, I would think that it would take, if at some showing of intent and some showing of harm. You've got neither here. And we had a full day evidentiary hearing to discuss it, and it is not in the transcript, it's nowhere in the record. It's clear Judge Martin, when he talks about spoliation of the evidence, he's referring to the Agricam lawsuit, and that has been debunked. It's unfortunate it's not in the index, but of course that could be supplemented if the court so desired. I think I'm probably having my 5 minutes.
Pretty close. Counsel, thank you. We appreciate your written filings. We appreciate your presentation today. We will take the matter under advisement. We will issue a written ruling in due course. Court is adjourned.